The Uganda Law Reforms Commission has had a consultative meeting with heads and members of Uganda Law Society in Kampala. This was after meeting with the Parliamentary Legal Committee Affairs. Wednesday this week, Uganda Law Society asked Uganda Law Reforms Commission to pay attention to acts in regard to human rights, the Penal Code Act, Succession Act, among other acts.
Clause 20 of the bill amends Section 4 of the Divorce Act, and specifically Section 42A. According to the proposed amendment, if left the way it is, it would mean one has to prove both change of religion and marriage. We propose that a clause on the amendment of the provisions relating to employment disputes resolution mechanisms be inserted into the bill, and the provisions be amended to remove or delete the provisions for complaint to a labor officer.
Other acts that raised concern from members was the Caveat Act 225 in regard to timeline given to the petitioner and the caveator to file a petition in courts of law regarding any dispute,
as well as that person who's lodged a caveat to oppose that application for probate or letters of administration are given 6 months to go to court. Now there is a technical difficulty there when both are given 6-month periods. One of the proposals is to adopt what happens under the RTA, the Registration of Titles Act, whereby the registrar of titles has some powers to give notice to the caveator, to come and give reason as to why your caveat should not be removed, etc. etc.
Other members raised concern regarding officers of Labour Commission, and they asked the Commission to pay attention.
We can have the law revisited so that Labour officers can be advocates or lawyers, and then also we do have a provision in the Employment Act.
Most of our proposals were on challenges we find in legal practice and how the law makes it difficult for us to be able to practice. We have cited an example of the Succession Act, and we have said the Succession Act, even the amended Succession Act, needs to be relooked at. As Uganda Law Society, what we have done is form a Uganda Law Society Reform Committee that is going to be looking at some of these laws.
The Commission, in replying to the raised concerns, pledged to address them to the Editorial Commission for action.
If somebody applies for letters of administration and you want to contest that, then you go to court. And when you go to court, you follow the procedure under the civil procedure rules, and it takes its course. And that's how it has been handled in court.
You may have many beneficiaries who did not lodge the caveat. So you're going to end up having very many people who keep on lodging the caveat just to defeat the purpose of the petition. So I think that's why the proposal is to go back to what we had under 269.
Over 90 acts are waiting to be repealed for being inconsistent, unconstitutional, and outdated in regard to the current situation. Deborah Namamonde, Tanawa Kenneth, UBC.